Hello friends, I am Advocate Supriya Sood. I welcome you all to this session on the basics of the POSH Act 2013. In this session, we will learn about brief history on enactment of the POSH Act, important definitions under the POSH Act, what all are the forms of harassment, how the internal complaints committee or the internal committee is formed or constituted, the complaint process, the filing of the complaint process, how it is done under the law, how the inquiry proceedings are conducted by the internal committee, and submission of the inquiry report. So let's start with our session. The Honorable Supreme Court in the matter of Vishaka and others versus the state of Rajasthan and others in the year 1997 had laid down certain important guidelines for effective enforcement of basic human right of gender equality and guarantee against sexual harassment and abuse at workplaces. These guidelines later on formed or laid down the foundation for enactment of the law, that is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, read with rules framed thereunder. In this session, we will collectively refer to the Act and rules as the POSH Act. The Vishaka Guidelines, in fact, is a landmark judgment of the Honorable Supreme Court where the working conditions of the women, particularly both in the organized and unorganized sectors, were addressed, and the women were ensured that they have a protection under the law, including imposition of certain penalties upon the employer. The POSH Act came into force on 9th of December 2013 with the object to provide protection to every woman, whether in a government sector, private sector or a public sector, both in organized and unorganized sectors, against the sexual harassment and to provide conducive working environment to the women and for prevention and redressal of their harassment complaints. Now let's come to certain important definitions. Aggrieved woman. Who is aggrieved woman? In relation to a workshop, any woman of any age, in any profession and at any designation, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent will be the aggrieved woman under the law. The important elements in this definition are: there is no age bar. A woman of every age, irrespective of her age factor, is covered under the POSH Act. There is no debarment that certain woman who is below certain age or is above certain age will not be in a position to take the advantage of the remedies provided under the POSH Act. Every woman is included, whether they are working in an organized sector or in an unorganized sector, including the domestic workers. They all are included under the POSH Act. Second element, important element in this definition is that it's not necessary such woman who alleges the harassment should be employed in the workplace, meaning thereby even a guest or a visitor are included under the POSH Act. The remedies available to a guest who visits the workplace or who comes into contact with the employees who are working in a workplace will be covered under the POSH Act. And the third element, important element in this definition is that there has to be an element of sexual harassment by the respondent. Mere harassment cases devoid of sexual element are not covered under the POSH Act. Now let's see another definition, that is the respondent. Respondent is a person against whom the aggrieved woman has alleged or has filed a complaint. Important word in this definition is a person. Now, can such person be only a man or a male? Answer is no. Therefore, I said the important word is a person. A person can be of any gender, even a woman who exploits or who harasses another woman will be termed as respondent. Person of any gender, even a third gender, will be included. Intersex genders are also included in the definition of the word respondent. The next important definition is what is sexual harassment. Sexual harassment includes any one or more of the following unwelcome acts of behavior, whether directly or by implication. Physical contact and advances. Next, a demand or request for sexual favors, or making sexually colored remarks, or showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature. Thus, this definition is very wide to include each and every act or behavior or conduct of a respondent against a woman. It's not necessary that a physical element has to be present to bring a case under the sexual harassment. Even a verbal demand or a request for sexual favor or intentionally showing a pornography to a woman will be covered under the term sexual harassment under the POSH Act. Or making a sexually colored remarks on the dress-up sense up of a woman or a dress-up choice of a woman, on the age or private life or personal life of a woman will be covered under the definition of sexual harassment. Now, harassment may take place in the following circumstances: implied or explicit promise of preferential treatment in employment, or implied or explicit threat of detrimental treatment in employment, or implied or explicit threat about present or future employment status, or interfering with work, or creating an intimidating or offensive or hostile work environment, or humiliating treatment likely to affect women's health or safety. Let's take an example. A supervisor, he requests a woman subordinate or demands a sexual relationship or a physical relationship with a woman subordinate. And in exchange of that, he promises a promotion or a pay rise to a woman subordinate. This will be an example of explicit promise of preferential treatment in employment. Now let's take this example further. The woman subordinate rightly declines or refuses the illegal, unjust demand of a supervisor. As a revenge, the supervisor threatens the woman subordinate to either withhold his increment, withhold her increment or withhold her promotion, or to write adverse performance appraisal report or a confidential report, or to ensure that she does not continue in the employment any further. Again, this will be the examples of implied or explicit threat of detrimental treatment or threat about the present or future employment status. Let's take another example. A woman subordinate has rightly declined or refused the illegal demand of sexual favors of the supervisor. The supervisor, in a meeting in front of entire team or office, intentionally humiliates the woman on her work performance or other matters. This will be a humiliating example of a humiliating treatment likely to affect the woman's health or safety, or unnecessarily interferes in her work schedule, or asks her to sit late in the office. This will be an example of interference with work or creating an intimidating or offensive or hostile work environment for a woman. Now, what is workplace? Workplace is a very wide term. Under the umbrella that is workplace, everything is included. For example, any organization, undertaking, department, establishment, office, branch, unit, whether of a government, central or state, whether a public sector organization or even a private organization. And it can be in the form of a society, office, trust, NGO, hospital, nursing home, any stadium, sports complex, so on so forth, any mall, any shop, or even a sales office, a factory, or can also include any place visited by the employee arising out of or during the course of employment, including the transportation provided by the employer, or any official offsites, official meetings, official get togethers, and so on and so forth. Anything where employee is required to be present in the course of her employment or during the course of her employment or his employment, that place will be termed as a workplace. Now, who is an employee? Just like the definition of workplace, employee again is a very wide term. It will include every person employed at a workplace for any work, whether as a regular employee, temporary or ad hoc employee, or a daily wage worker, whether he is employed directly by the employer or through some agent or contractor. If employed through any agent or contractor, it's not necessary that the principal employer or the employer should have the knowledge of employment of such person or the employee. Whether the person works for remuneration or not, or works on a voluntary basis or otherwise, or works for daily basis, daily wage basis, or on any terms or conditions of the employment, will be covered as an employee, including any contract worker, any part-time or fixed-term contractor worker, probationer, trainee, apprentice, intern, or by whatever name called. Thus, every person who is employed to do the work at a workplace will be covered under the definition of the term employee. Now, let's see how the complaint of sexual harassment can be filed. Before that, the law says that it is the duty of the employer to constitute or form an internal committee or the internal complaints committee. Both the terms are interchangeable. In May 2016, the term Internal Complaints Committee, that is ICC, was named as Internal Committee, that is IC. In this session, we will refer the term as IC only. The IC shall consist of members who shall hold the office for a maximum period not exceeding 3 years from the date of their appointment. It is mandatory that at least one of the total members on the IC board shall be the woman. Now, who all are the members of the IC? Number 1, presiding officer. The presiding officer necessarily has to be a woman who is employed at a senior level at workplace. Now, please note that if the employer has more than one unit or has branches or offices in multiple jurisdictions or places, it is mandatory, and where 10 or more employees are employed, it is mandatory for the employer to have a separate IC for all the units or branches or offices. And presiding officer in all these ICs has to be a woman who is working or is employed at a senior level at workplace. Secondly, there has to be 2 members from amongst the employees as part of the IC, and such employees preferably should be committed to the cause of a woman or who have experience in social work or have a legal knowledge. Why it is mandatory that other 2 members minimum, the law says not less than 2 members, that is, it means that minimum 2 members amongst the employees have to be part of the IC in addition to a woman presiding officer. Why we say that employees should have the experience or knowledge of social work or have a legal knowledge or should be committed to the cause of a woman. The reason being that harassment issues are not only complex or legal issues, but any member who deals with these issues should understand the psychology of a woman who has unfortunately undergone the harassment at a workplace and who should be able to handle such cases with experience and knowledge. Next is one member from amongst non-governmental organizations, NGOs, or associations committed to the cause of a woman or a person familiar with the issues relating to sexual harassment. Why external member is mandatory? The member from NGOs or external or a person familiar with the issues relating to a sexual harassment, he will be termed as external member. Why they are mandatory or necessary? Because to bring impartiality and fairness in the inquiry proceedings and to have independent and expert knowledge or outside perspective to the inquiry proceedings and to understand the trauma or the psychology or the real issue behind the harassment cases. Now, how a complaint is to be filed? A written complaint is to be filed by a agreed woman, either herself or with the assistance of the presiding officer or any member of the IC within a period of 3 months from the date of the incident. And in case of series of incidents, within a period of 3 months from the date of the last incident. Please note, this is very important point, a limitation period provided under the law. Please ensure that woman employee files a complaint within a period of 3 months if it's a sole or a single incident within 3 months from the date of the incident, sole incident, or within a period of 3 months from the date of the last incident in case of series of incidents. The IC, although may, on the written application to be filed by the agreed woman to condone the delay and showing the sufficient or the satisfactory reasons, may condone the delay and extend the limitation period for filing the complaint by another 3 months. But it's always advisable that a woman, agreed woman, should not wait for 6 months to file the complaint. Thus, the maximum period, including the first 3 months, and in case IC condones the delay and grants another time limit, maximum 6 months are provided under the law to file a complaint. A complaint, agreed woman or a complainant shall submit 6 copies of the complaint along with list of documents and the names and addresses of the witnesses. On receiving the complaint, the IC shall forward the or hand over or shall supply copy of the complaint along with the supporting documents and names and addresses of the witnesses which woman has filed to the respondent within a period of 7 working days to enable the respondent to file his reply or justifications. The respondent must file his reply or justification within a maximum period of 10 working days from the date of receipt of the documents. This is another set of important limitation period provided under the law. The term incident, as we have seen in the preceding slides, that complaint has to be filed within a period of 3 months from the date of the incident. The term incident means the incident of or act of behavior of sexual harassment. Now, let's see the scenarios where agreed woman is unable to make a complaint herself on account of her physical incapacity. One, we have seen that complaint can be filed with the assistance of the presiding officer or any member of the IC, or complaint can be filed through SHE-Box, Sexual Harassment in Electronic Box, an initiative of the Government of India. But if complaint cannot be filed by an agreed woman due to her physical incapacity, then complaint can be filed by her relative or a friend, her co-worker, an officer of the National Commission for Women or State Women Commission, or any person who has a knowledge of the incident with the prior written consent of the aggrieved woman. There can be another scenario. If aggrieved woman is unable to file a complaint due to her mental incapacity, then a complaint may be filed by her relative or a friend, or a special educator, or a qualified psychiatrist or psychologist, or a guardian or authority under whose care aggrieved woman is receiving medical treatment or care, or by any person who has a knowledge of the incident jointly with any of the above said persons. Now let's see what is the process after complaint has been received by the IC. After the complaint is received by the IC must ensure that the complaint as filed under the POSH Act is maintainable under the POSH Act. That is why? Because not every complaint can be entertained under the POSH Act or by the internal committee or the IC. Only the complaints which have the element of sexual harassment can qualify to be entertained by the IC, or in other words, IC will have jurisdiction only to entertain sexual harassment cases, not any other complaints. If IC arrives at a conclusion that yes, complaint is maintainable, then and if the woman employee or the aggrieved woman requests the IC in writing to initiate the conciliation process, then IC will initiate the conciliation proceedings between the complainant and the respondent to settle the matter amicably. Kindly note, in conciliation or settlement proceedings, a woman cannot demand monetary settlement, and or respondent cannot offer a monetary settlement as basis of the conciliation. If the conciliation is arrived at, settlement is arrived at between the aggrieved woman and the respondent, then IC shall record the terms or conditions upon which settlement has been arrived at and forward a copy of the settlement to the employer along with one copy each to the complainant and the respondent. The complainant means the aggrieved woman here. In case of settlement, there will be no necessity or there is no requirement to conduct the inquiry proceedings any further. It will come to an end unless the aggrieved woman informs the IC that the respondent has breached any terms or conditions of the settlement. The IC shall proceed to make the inquiry into the complaint in cases where aggrieved woman has not requested for a conciliation, or where conciliation has failed, or conciliation could not be arrived at, or the woman informs the IC that respondent has breached the terms or conditions of the settlement. Then IC will proceed to initiate the formal inquiry as per the service rules applicable to the respondent and in terms of principles of natural justice. The term principles of justice here means an opportunity of being heard, of defense, an opportunity to produce the evidences and witnesses is provided to the respondent, and also an opportunity is provided to the respondent to cross-examine the complainant's or aggrieved woman's witnesses. In case the IC fails to follow the principles of natural justice, entire inquiry proceedings will be held to be null and void and illegal and of no effect. The minimum 3 members of the IC shall be present for conducting the inquiry. Neither the complainant nor the respondent shall be allowed to bring in any legal practitioner or advocate to represent them in the inquiry proceedings. The IC is a quasi-judicial body. Thus, it has a limited powers of a civil court for summoning and enforcement of the attendance of any person and to examine any person on oath. It has a power to require discovery and production of documents or any other matter which may be prescribed under the rules, POSH Rules 2013. The IC shall have a limitation period of 90 days to conduct and conclude the inquiry. During the pendency of the inquiry, if the aggrieved woman requests, the IC may recommend to the employer to transfer the aggrieved woman or respondent to any other workplace or grant leaves to the aggrieved woman up to a period of 3 months, and such leave shall be in addition to the leave which aggrieved woman is otherwise entitled to, or restrain the respondent from reporting on work or performance appraisal of the aggrieved woman, or writing her confidential or performance report, or restraining the respondent in case of an education institution from supervising any academic activity of the aggrieved woman. In case after filing the complaint, the complainant or the aggrieved woman fails without sufficient cause to appear before the IC, after the meeting is convened by the presiding officer, her case or her complaint will be dismissed, provided advance written notice of 15 days is given to the complainant, informing her that she needs to be present, and in case of default, her complaint will be dismissed. Similarly, if the respondent fails to appear before the IC for 3 consecutive hearings, as are convened by the presiding officer, the ex parte order or decision will be passed against him, subject to the condition that before proceeding ex parte, advance written notice of 15 days is given to the respondent, informing him that he needs to appear before the IC to defend himself or to give his reply, and in case of default, ex parte order or the decision will be given. Ex parte decision means in the absence of the respondent. On completion of the inquiry, the IC shall provide a report of his findings to the employer, detailing therein its reasons for arriving at the decision, and that it will also give the its recommendation to the employer. And such report has to be filed with the employer within a maximum period of 10 days from the date of completion of the inquiry. Please note, it is the legal right of the complainant and of the respondent to get a copy of the inquiry report. The employer shall act on the recommendation of the internal committee within a maximum period of 60 days from the date of receipt of the inquiry report. If the IC arrives at the conclusion that the allegations against the respondent has not been proved, then of course it will recommend to the employer that no action is required. That is quite obvious, to be taken against the respondent, or no action is required in the matter or in the complaint. However, if the IC arrives at the conclusion that respondent is guilty of the sexual harassment, then it will recommend to the employer to take action against the respondent as misconduct as per the provisions of service rules applicable to the respondent, and if there are no service rules, then to ask for a written apology from the respondent, or issue a warning letter to the respondent, or reprimand or censure the respondent, or withhold his promotion or pay rise or increment, or terminate him from the service, or ask him to undergo a counseling session or carrying out the community service. In addition, the IC can also recommend to the employer to deduct from the salary or wages of the respondent certain amount basis the mental trauma, pain, etc. suffered by the aggrieved woman, or loss in her career opportunity due to the incident of sexual harassment, basis the medical expenses incurred by the aggrieved woman for her physical or psychiatric treatment, and while recommending deduction from the salary or wages of the respondent, IC must consider the income and the financial status of the respondent and feasibility if such payment can be made or recovered or deducted in lump sum or in installments. Now, in this session, we have seen certain important basics of the POSH Act, right from important definitions, also the importance of formation of the IC, how a complaint can be filed, including by way of a she-box, and how the inquiry proceedings are conducted and how the report is submitted, and what all actions can be recommended by the internal committee to the employer. Please note that every employer, irrespective whether they are government sector, they are private sector, or they are public sector employers, needs to register themselves now on the Government of India's portal, on she-box portal. Otherwise, the complainant will not be able to file their complaint, and this will be treated as violation or breach of the statutory requirement, and the employer shall be guilty of the penalty which can extend to rupees 50,000 or cancellation or non-renewal of his business license or registration. That we will see in the next session, what all penalties can be imposed on the employer for non-compliance. With this, we come to an end of the first session. I hope you must have understood some important basics of the POSH Act, including the important limitation period that complaint has to be filed within 3 months. The IC has a power on sufficient reasons to be shown to extend the timelines of filing the complaint by another 3 months. If complaint is not filed within 3 plus 3 months, that is in 6 months, then the complainant loses her right to file a complaint. The inquiry has to be conducted within 90 days. The report has to be submitted within 10 days and employer has to take the action within 60 days. Also, the respondent has to file his reply within 10 days, 10 working days from the date of receipt of the complaint along with the documents. Students, thank you very much for this session. We will meet you in the next session now. Thank you once again. Have a good day.